rely on the information provided without consulting an attorney who is licensed to provide legal advice. Topics and ideas shared on this show are not to be used as a substitute for legal advice from a licensed attorney in your state.
Welcome to Under Oath with Michelle Bell. I'm your host, Michelle Bell. This is a show where I bring on other attorneys and we give you, the audience, legal information. I like to start the show off with a segment I call Jury Duty. And that's where I'll give a trivia question, and then the first person to send the correct answer to the website, their name will be posted on the website and they'll receive a gift. And the website is www.mbunder.oath.com. So ready for the question? Here we go. In honor of the Super Bowl that's coming up, what football team had the biggest scoring comeback in the history of the Super Bowl? That should be an easy one. I look forward to your answers. So don't go anywhere. We'll be right back with my great guest that's coming on. It's just so much information. You'll love it.
You made your house a reality. Homeschooling yourself on loans, color-coding listings, and flushing every toilet in a 20-mile radius. If you can ace house hunting, you can do it for retirement. Get on track with tips at aceyourretirement.org.
Welcome back to Under Oath with Michelle Bell. I'm your host, Michelle Bell. And I'm here with my great guest, Jacqueline Williams. Yay! She's an attorney and practices criminal law as well as employment law. So welcome.
Thank you. Thank you. Thank you. Thank you.
Great. So, okay, tell me, how did you get into law?
Oh, jeez. Well, I always wanted to be a lawyer ever since I was probably 9. I remember asking my mom, I don't know where we were. Oh, actually, I used to watch Perry Mason with my grandfather. And I remember asking my mom one day, do you think I could do that? You think I could be a lawyer? She's like, yeah. You know, your mama tells you, yeah, baby, you can be anything, baby. You want to be president, you can be whatever you want to be. And I believed that. Mm-hmm. And so I went to undergraduate school, majored in criminal justice. And then after that, I didn't go directly into law school. I decided to go work as a corrections officer. And I think at that point I decided, I don't know if I'm going to be a lawyer. I don't know if I'm still going to do that. But I worked as a juvenile corrections officer in Atlanta. And working with those kids really inspired me. And so they inspired me to apply for law school. And the rest is history.
That's awesome. That is awesome.
That's cool.
All right. So we're going to get right into what are you going to tell the public today?
Well, I would like to talk to people about what happens after you get arrested.
Oh, so we doing criminal law.
We are.
All right. So we're going to take it from when you get arrested.
We're going to start from when you get arrested, and we're going to take it sort of an overview, sort of the nuts and bolts through trial. So.
All right. No, that's what people need to know. So what
Absolutely.
happens once you get arrested? This isn't just the cops bring you in asking you questions. This is arrested.
That's right. That's right. The cops have already decided that you are the person that they want to bring in. And so you're in handcuffs, you're in the back of the squad car, and you're headed down to central booking, or depending on what jurisdiction you're in, you might be just headed to the precinct. But in any event, you're in police custody. Okay. What do you do now?
Yes, what do you do?
Yeah, a lot of people don't know. A lot of people make the mistake of speaking to the police and giving a lot of information about the incident, whatever happened, whether it was a fight between two friends, a fight between two loved ones, possession of heroin, possession of marijuana, possession of crack cocaine. A lot of people begin to speak to the police about their case when they shouldn't.
So no, be quiet. Stop talking.
Be quiet. Be silent. A lot of people don't. They know that they have Miranda rights, right? Mm-hmm. And people are always like, well, he didn't read me my Miranda rights. But then I find out there were like all these statements given that weren't the product of police interrogation. So it wasn't like the police were asking
They
questions.
were just volunteering information.
Just yep.
They freaked out and forgot the golden rule.
That's correct. And
Quiet.
Exactly. And so the people have given the police a lot more than the police would have had. And then ultimately they've given the prosecutor a lot of power over their case and over their fate that they wouldn't have been able to give them had they not started talking.
Right.
So you get arrested, you're down at the precinct, and then the police officer in most jurisdictions is then required to send his police report over to the in DC, the U.S. Attorney's Office or the Attorney General's office. In, let's say, Brooklyn, New York, it's the Brooklyn DA's office, the District Attorney's office, and most jurisdictions have a district attorney. DC is obviously different because it's a federal jurisdiction, but the police paperwork goes over to the prosecutor's office. The prosecutor then has to make a decision about whether or not they actually want to, what we call paper the case, meaning whether or not they want to actually create a case, create a file for you. Well, not you, but the person who's
right.
Hopefully
no,
never
not me.
you.
No, I paid too much for this degree. I don't know. That ESQ was expensive.
Right. So they decide whether or not they're going to paper the case. If they decide they are going to paper the case, that means that your case is going forward. The person's case is going forward, and then the next step will be an arraignment. And there are some nuances between arraignment and what's called presentment, but that's for felony cases, and I won't get into those nuances. In most jurisdictions, it's an arraignment. And at an arraignment, that's where you learn of the charges against you. At that point, you have an attorney present for you in most jurisdictions, and that attorney will plead not guilty for you, assert your rights under the Constitution and under the 4th, 5th, and 6th Amendments in that proceeding, and it will cover any future proceedings as well.
Okay, wait a minute.
Okay.
So you're telling me that this person is arrested, and they don't even know what they're being charged with until they get to the arraignment?
Quite possible, yes.
Does the arraignment happen in the same day, or is one of those things where you get arrested at night and you won't know till the next day?
That's right. And if you get arrested on a Friday, then if you get arrested Friday night, you are not going to see the judge until Monday morning. So you will spend the entire weekend
Not
in
even
jail.
a magistrate is on duty on the weekend?
In D.C., there is a magistrate on duty on Saturdays, but it depends on what time you get arrested. So the magistrate goes up at like 11 a.m. or 1 o'clock, and then he's done, or he or she is done at 4 or 5. So if you didn't, right?
So you have to make sure you
that's right.
don't
And
get
if
arrested
they're-
after 5.
That's that's right. So and remember, there are lots of people who got arrested before you. So they're in line before you. So everybody who got arrested 4 a.m. on Friday, they're going to be seen by that judge on Saturday, hopefully. But for the most part, yeah, you're gonna be sitting in there.
Okay. So yeah, you're at arraignment. You're just finding out what they're charging you with. You know, you got that shock face, like, wait, what? That too?
That's right. That's right. And a lot of people don't know. Sometimes the police will tell them, well, we're only going to charge you with this. And then the U.S. Attorney's Office or the District Attorney's Office decides, no, we're going to charge them with this too. So we're not only going to charge them with destruction of property, but we're also going to charge him with unlawful entry because the property he destroyed was in a place that he wasn't supposed to be in. So sometimes they'll charge you with everything possible. Sometimes the government will overcharge a case, and then you have to later decide which one you're going to plead guilty to or go to trial on. But
So you're
we'll
going to
get
throw
to
the
that.
kitchen sink and see what sticks.
That's right.
Okay, good.
That's right.
All right, so you go through arraignment. You say not guilty. Judge says what?
At that point, the judge has to decide whether or not to release you or to hold you at the jail. DC is an interesting jurisdiction, and they have a very good policy in that you either are being held because you have a pending case, or you've been charged with a dangerous crime, and they believe that the public safety is in jeopardy, and they don't want to release you, or you get released just on your own personal recognizance. So it's not like jurisdictions like New York where they might, the judge might give you a $200 bail. And for some people, that's nothing. But for a lot of people, you might be sitting in jail because you
Right.
can't post $200, or your mom doesn't, your mom doesn't
Right,
have $200.
you got arrested because you were stealing food to eat because you didn't have food.
Yeah.
So yeah, you're not gonna have the $200
That's right.
because you didn't have the money to buy the stuff you got in trouble with in the first place.
That's right.
So understood.
That's right. So, so DC and other jurisdictions are moving towards that as well, and it's really a fairer system because it means that your incarceration or your ability to avoid incarceration is not, dependent on your social economic status.
Right.
And because we have so much poverty in this country, you see a lot of people in jail for petty crimes because they couldn't post $50 bail, because they couldn't post $25 bail, and $25 is a lot to somebody who's
It is.
panhandling.
Right.
So you either are held or you get released. Either way, you get another date to come back to court.
Okay.
And you come back to court in DC, you don't see the judge who arraigned you. You go to another judge. And at that point, between the time that you were arraigned and the time that you go back to court again, your lawyer, hopefully, will have spoken to the prosecutor and gotten what's called a plea offer.
Okay.
And the plea offer is basically the government's attempt to bargain with you to get you to plead guilty to the offense that you're charged with. So let's say the person was charged with destruction of property and also unlawful entry. And in DC, both of those carries a maximum penalty of 180 days in jail and or a $1,000 fine. The government might say, hey, look, I know you're charged with 2 offenses, but plead guilty to one, we'll drop the other one. The person then has to decide, do I want to actually plead guilty, or do I want to take my case to trial because I'm not guilty? Or, yes, I destroyed the property, but I have a reason for why I destroyed the property. Or, yes, I was unlawfully in the Safeway or in this person's home, but I have a reason for why I was there, right? Or maybe I shouldn't have been there, but I was forced to be there. Or there are a ton of different defenses a person might have at play. So a person has to decide, do they want to take that plea offer, that bargain, or do they want to take their case to trial? Because that's your only other option. Unless the government gives you some kind of disposition that gets your case dismissed. For example, in DC, they offer what are called deferred prosecution agreements and deferred sentencing agreements. And in most cases, what that does is it gets your case dismissed after you finish a certain number of hours of community service.
Oh, okay.
Now, the difference between the two of those is in a deferred prosecution agreement, you do not have to plead guilty first. You just sign an agreement with the government that says, I'm going to do 30 hours of community service, and then I'm going to come back to court on the next court date 6 months from now. And if I'm done with that, the government's agreeing to dismiss my case completely.
But you also have to have not committed another crime.
That's
or got
correct.
Caught for committing another crime.
That's right. That's right.
So you have to be nose clean,
That's right.
do your community service, and then you can
That's right.
be okay. You're like, hey, I did it.
That's
Let me
right.
out.
That's right.
Now,
And
does it stay on your record, though?
it does.
Or it's not even on your record?
It's not a conviction, so there's no conviction on the record. But what does stay on the record, and a lot of people don't get this cleared up, is the arrest. So the arrest stays there unless you file a motion with the court to have it sealed.
Okay.
And that's not an arduous process, but most people don't do it. They just are happy to be out of the system and home. So they don't follow up
And
and
they're
get the
not really
sealing.
out of the system.
That's right.
So, okay. We'll get more into that. We're going to take a break right now. And then when we come back, we're going to go into office hours where we had questions that were sent in.
Okay.
And you can answer them.
Wonderful.
Okay?
All right, great.
We'll be right back.
Caring for a family member can be challenging and lead to countless questions for them and for you. Find articles, tips, and tools from experts and others who have been in your place. The Caregiving Resource Center at aarp.org/caregiving.
Welcome back to Under Oath with Michelle Bell. I'm your host, Michelle Bell. And I'm here with Ms. Jacqueline Williams. All right, yay! So now we're going to go into the next segment, which is office hours.
Okay.
And that's where we have questions from the audience. They were submitted to us. And you just answer them,
Okay.
okay?
Sure.
As best that you can.
All right.
Now, these were emails, so you're not going to hear audio or see a video like, our audience is probably used to.
Okay.
I'm going to read them off to you. So the first question is, I got arrested after riding in a car with a friend who had drugs inside of a cup that was sitting in the cup holder. Why did the police arrest both of us? The car isn't mine.
Wow, good question. And this happens pretty frequently. Short answer is the reason why the police can arrest you is they're arresting you on a theory of constructive possession. If there is a cup, if it's in the car in the center console where everybody can see it, and it's got drugs in it, well, it could be yours, it could be mine, it could be the person in the back seat on the passenger side, or the person in the back seat on the driver's side. And so the cops can arrest everybody on the theory that that belongs to somebody in the car, because everybody was in close proximity to it and could see it. So be careful who you ride with.
Right. Yeah, get your friends. The next question, you ready?
Yep.
Okay. I was arrested recently and the police did not read me my rights. Can I have my case dismissed?
Talked about this a little bit earlier. The police do not have to read you your rights unless they are questioning you about the case, unless what they're questioning you about is the product of police interrogation. They're asking you questions that are likely to elicit an incriminating response from you.
Okay, so if they just want to ask you just about stuff.
Just, yeah, basic investigatory questions are okay, but once they started getting into, well, whose is this, and what did you do, and what was your involvement? Well, those are all questions that could cause a person to say, well, I had this level of involvement, or I did this, or I was in this place or that place. And if that type of questioning is taking place, you have a right to have a lawyer. You have a right to remain silent until you get a lawyer. And so it's important for people to just shut up.
If the police didn't read them the rights at that point, then your case can be dismissed.
The statement can be thrown out.
Oh, but not the case dismissed.
That's right.
Just off of that.
Right.
Got it.
But sometimes a case for a prosecutor can hinge on a statement that was made, a confession that was made.
Right.
Maybe that's the strongest piece of evidence that the government has. So if your lawyer files a motion to get those statements suppressed, then you got a good chance that your case could get thrown out.
Cool. Okay. All right. We have one more question. All right. I have a public defender as my attorney. Am I in good hands, or should I hire my own attorney? You know, public defenders get a bad rap. Oh, my goodness.
Oh, they get such a bad rap.
I love you, public defenders.
Short answer is yes, you are in good hands with a public defender. Some people don't even think that public defenders are lawyers. They'll say, oh, I'm going to get a lawyer because right now I have a public defender. And your public defender is a lawyer. He or she went to law school. And in some jurisdictions like New York and D.C. and Louisiana, other places that I've been, have some of the best public defenders, some of the best credentialed public defenders that I've ever seen, some of the best trial lawyers I've ever seen. So yes, you are in good hands. Obviously, there are some jurisdictions where the public defenders are a little bit overworked, they're definitely underpaid, and they've got a heavy caseload. So I would say to someone, if you feel like your public defender isn't giving you any time on your case, then you might want to consider finding private counsel.
That is like the best answer I've heard concerning public defenders. They get such a bad rep, and it's horrible.
They do.
So, well, great. Thank you for answering the questions from office hours.
Sure.
And to go back to what you were saying before we took the break, so if we have a person, they take the plea deal or they go to trial. Right. So what happens if that person decides, you know what, I'm not taking this deal. I don't care what you're saying. I'm going to go to trial. I'm going to be in front of my peers. I'm going to give my case, and I'm going to have my day in court.
You know, that's a decision that a lot of people make, and I applaud people who do, especially if the government is not giving them when I say the government, I'm talking about the prosecutor or the district attorney. If you're not really getting a deal, meaning the government will sometimes say, well, you're charged with unlawful entry, now plead guilty to unlawful entry. Well, it's like, well, I could go to trial, lose, and still have a criminal unlawful entry on my record. So some people say, I'm going to roll the dice, and I'm going to go to trial. Now, some cases, some offenses are jury demandable, like felony matters are jury demandable, and some misdemeanors are jury demandable. And in some jurisdictions, lots of misdemeanors are jury demandable.
Okay, now when you say jury demandable, what do you mean?
Meaning you can make a demand for a jury to decide the case. to actually hear the facts of the case.
So you don't automatically get the jury. You have to demand for a jury to have a jury trial.
Well, so you can, if it is a case that is in which you're entitled to a jury, and that's usually depending on the offense or the amount of time you have that you could do in jail based on that offense. If it is a case that the law entitles you to a jury on just because of the status of the offense, then yes, your lawyer will automatically make a demand for a jury trial. Now, you can waive a jury trial in some cases. So there are some misdemeanor cases where you might say, do I really want a jury to hear this? Do I really want to go through a jury trial, or do I just want to have a bench trial? And a bench trial is when the judge makes a decision on your case. Here's all the evidence in the case, much like a jury would, but the judge makes the decision and not the jury. Okay. So I like what you said about a person saying, I want a jury of my peers, because I think about sometimes when I see juries, they don't look like the defendant.
Right.
And so, it begs the question, is this really a jury of his peers? Because all his peers are like from Southeast DC, or, they're from,
right,
from
Bronx,
Southwest
New York,
Atlanta.
Brooklyn,
right, exactly.
right.
Exactly. So,
Queens.
Right. But it doesn't mean you can't get a fair trial.
Right.
It just means, when you think about this notion of a jury of someone's peers, sometimes the makeup of the jury looks nothing like this person's, who's on trial. It looks nothing like their peers.
The expectation they have is I'm going to see a couple faces that look kind of like mine.
Yes.
But then when you get it, you're like, wait a minute.
Right.
Wait a minute. No.
That's correct. So you never know, and you never know what your jury pool is going to look like.
Right.
You never know. You never know. But so a person makes a decision, they're going to go to trial. At that point, the lawyer will file, if they hadn't done so already, a series of motions to suppress your statements, motion to suppress the gun that was found, motions to suppress the identification of a witness based on either the suggestiveness of an ID procedure that was done by the police, the suggestiveness of a lineup that was done that you were put in, that was done by the police. Your lawyer will file all kinds of motions to get those things basically thrown out.
Right.
So we use the term suppress, but it's basically thrown out.
Okay.
So after all those motions have been decided by the judge, then a person goes before the jury, or they have their case tried before a judge. And if their case is tried before a jury, the process is the same with the exception of jury selection. The process is the same. The government's going to put on its case in chief, meaning they're going to put on all the witnesses in their case. They're going to put on the civilian witnesses, whoever the complaining witnesses that said that my client knocked him over the head. They'll put that person on. Then the prosecutor will put on the stand the police officer who arrested my client. Or if there were fingerprints, that evidence will get introduced. Any experts will be put on the stand. Then the defendant's lawyer will have an opportunity to cross-examine those witnesses. After the government is done putting on their entire case, then the defense has an opportunity to put on their case. The defendant can testify in his own defense if he wants to. He doesn't have to. But sometimes jurors do want to hear from the defendant. But if he decides not to, they're not supposed to use that against him because he doesn't have a burden of proof.
Right.
The burden of proof remains with the government to prove his guilt beyond a reasonable doubt. And so, but once the defense is in their case in chief, they can do exactly what the government did. And the government would have an opportunity to cross-examine all of their witnesses. So any witnesses that the defendant might have had to the incident, the government would be able to cross-examine those individuals. And after that, they give closing statements. A couple of other motions that I won't bore you with are made. And then the jury will deliberate in the deliberating room. They'll retire to the deliberating room, and they'll make a decision about a person's fate. Or the judge will make a determination on his own, and he or she usually will make that just directly from the bench based on the information that he had an opportunity to hear.
Okay, on average, quickly before we go into the next segment, but on average, how long is a trial?
Oh, good question. Some trials take an hour. Some trials take 6 months. So it really just depends on the number of crimes charged, the number of defendants. Sometimes you have, I was recently on a case with where we had a total of 200 people indicted. Oof. Yeah, and so the government was trying about 20 to 25 people at a time.
Oh my goodness gracious.
Very.
Okay, you got to tell me details about that later, because I just have to hear how you handled 200 people being indicted. That's crazy.
Oh, it's
and
bizarre.
in groups of 25. I can imagine.
It was
I
an
can imagine.
bizarre case.
That's like Law and Order on steroids. Oh, so this is great information. So we're going to take a break, and when we come back, we're going to go into one of my favorite segments, which is Plead the Fifth.
Okay. Uh-oh.
And then Cheat Sheet, which is, you're going to give the audience some tips.
Okay.
And then we'll let them know how they can contact you if they have any questions, okay?
Okay. All right, great.
All right, so we'll be right back.
Patriotism. It inspires passionate debate. It's worn like a badge of honor with good reason, because it means love and devotion for one's country. But what really makes up this country of ours? It's the people. To love America is to love all Americans. This year, patriotism shouldn't just be about pride of country. It should be about love. Love beyond age, sexuality, disability, race, religion, and other labels. Because love has no labels.
Welcome back to Under Oath with Michelle Bell. I'm your host, Michelle Bell, and I'm here with Miss Jacqueline Williams.
Hi.
Hey. So now we're going to go into the next segment, which is Plead the Fifth. Now, how Plead the Fifth works is I'm going to ask you a series of questions. You can either answer them or you can plead the fifth.
Okay.
Okay?
Sure.
You ready?
Mm-hmm.
All right. What is your excuse to get out of exercising?
Oh, jeez. I'm going to plead the fifth.
Really? That's like the first one.
My husband might watch this.
Okay. Invisible, what is something you would do?
I would go into the White House.
Oh, okay. All right. Have you ever cheated to win a game?
No.
Really?
Yeah,
Not even a Monopoly?
no.
Oh, gracious. Have you ever bought something to wear to an event and then returned it to the store when the event was over?
Yes.
You have?
Mm-hmm.
Wow. And have you ever cheated on a test?
No. I'm not cheating. I know you're looking at me. I see you giving me that look. No.
I'm going to plead fifth on that one myself.
You'll plead for
But,
me.
right. So there you go. Thank you for playing Plead the Fifth.
That was fun. Thank you.
So now we're going to go into Cheat Sheet.
Okay.
Now, Cheat Sheet is where you give the audience, 3 basic tips that they need to know.
Okay.
So what are your tips?
All right. So my first tip would be something I've discussed before. Don't talk to the police without a lawyer present. Avoid it at all costs. You can give the police your name. You can give them your phone number. Do not give them any information about the incident that they want to speak to you about. Not without your lawyer present.
To be safe, don't say anything.
That's right. You can always talk to the police later or the prosecutor later when you have your lawyer present, but be quiet. The other thing is, and we're seeing this a lot, but turn on your phone and record encounters with the police whenever possible, whenever you can do so safely, because obviously phones look like weapons, and so you want to be really careful. If you're being pulled over by the police, pull your phone out before the police officer gets out of his car. So before he walks up to your car and is in your view, have your phone out and have it on record encounters. Even if you can't get video, if you can get audio, sometimes that's helpful.
Okay.
And then the third one would be stay on the jury. Don't get out of jury duty if you get called for jury duty, especially in a criminal case. Stay on the jury. There are countless times when I'm on trial. It's a very serious offense. My client's really young, and I need people who look like him on the jury. Not that people who don't look like him can't be fair, but I need people who look like him, who may have had some of the experiences that he has had, who may understand cultural differences or cultural nuances. I need those people on the jury.
I know, but nobody wants to stay at jury duty all day.
You know what? Then don't complain about the overcrowding of the DC jail. Don't complain about the prisons being overcrowded. And these are all things that people complain about, and they say they want to see justice done, but nobody's willing to stay on the jury to see the justice is done, even if justice has to be done for the victim. because you know, sometimes it doesn't go the way we want it to as defense attorneys. Sometimes justice is just served, but sometimes it goes the other way, and someone who should not be convicted is convicted. And so we want to avoid that, but stop looking for reasons to get out of jury duty. No more, my religion won't let me judge. Yes, it will. Yes, it will. Yes, it does. You know, no more of that.
Well,
I gotta go.
I never looked at it from that perspective, so that was great. But thank you for being on the show.
My pleasure. Thank
It
you
was
for having
wonderful.
me.
So if anybody has any more questions or they want to reach out to you, how can they contact you?
They can go to my website, which is www.jacquelineWilliamsesq.com, and that's JACQUELINE, Williams, common spelling, ESQ.com. And my telephone number is 202-735-1444.
Great.
Thank you for having me.
Oh, of
You're
course.
awesome.
Anytime. Oh, thank you. Anytime. And I thank you for tuning in to watch the show. So any more information you want, you can go to the website, which is www.mbounderoath.com. When you go there, you can definitely watch the past shows, but you can also put in the information that, you know, if you want to answer the questions from jury duty, or if you want to submit your questions for office hours. And we'll see if it gets put on the show and answered for you. Okay? See you next time.